Hi, this is Dan Smith of DPS Legal Counsel, and today I want to talk about the HIPAA Right of Access initiative that has been in place for a little over a year from the Office for Civil Rights within the Department of Health and Human Services. As you may know, the OCR, or the Office for Civil Rights, instituted what's called a Right to Access initiative under HIPAA about a year ago. And since that time, OCR has investigated and entered into settlements with a number of covered entities, healthcare providers, who failed to provide proper and required access to medical records requested by patients from that particular provider. And just last week, on Friday, November the 6th, 2020, the OCR published a notice of the most recent settlement that it had entered into with a health care provider. This is the 10th one under this Right of Access, or Right to Access initiative. Now, just to give you some context about the 10 settlements that have been, public notice has been put out there so far under this initiative. The provider that entered into the settlement with the government had to pay basically a fine or a fee for settling with the government on, allegedly at least, not providing the access required under HIPAA. That penalty, that fine, that fee for settlement has ranged from a low of $10,000 all the way up to a high of $160,000. The one that happened last week, the most recent one, the settlement amount was $25,000. There were actually two in October, one of which was $100,000 and one of which was $160,000. The very first couple of settlements the government entered into with providers back in around September of 2019, in that range of time, were both $85,000. And so you can see it's a serious issue for providers to not comply with this right to access for medical records when requested by patients. Not only is it improper and a violation of HIPAA, but the Office for Civil Rights can enforce that requirement, and if they do that, not only are you going to have to pay legal fees in addressing the government's enforcement action, but you're going to end up paying a settlement amount to the government, which so far has ranged from a low of $10,000 all the way up to $160,000. So it's an important thing to keep in mind, to make sure that when patients request their medical records, that you provide the required access to those records under HIPAA. Now, what are some of the things that that you need to know about in this area? One is that you can require that a patient make a request in writing, and you do need to verify the person who's making the request that they are a proper person, a patient, or a representative of a patient to make that request. But there are a number of things you cannot do. You cannot require, for example, that a patient come to your office physically to make a request for records, or to verify their identity. You cannot require that they actually come to your office to do that. You cannot require that the patient utilize a web portal on a website that you maintain in order to make a request or to verify their identity. You can allow it, but you can't require it. You cannot require that the request for documents or for medical records be sent to you by mail. So these are things you cannot require. You need to be very flexible in making sure that patients can easily request their records and can easily verify their identity, and not put up these issues or problems that might prevent them from being able to do so. Well, another thing you must do is, if you need to provide the records in the format that the patient requests. For example, if a patient requests that their records be provided to them on paper records, and if you maintain records on paper, you need to provide them on paper. If you maintain your records electronically and they request them on paper, then you need to also be able to copy those electronic records onto paper to provide them the records in that manner. If a patient requests electronic records and you maintain them electronically, then you need to provide those records electronically. If you maintain your records on paper only and a patient requests them electronically, you need to be able to provide them electronically if it's readily available to convert your paper records to electronic records. That might be a little problematic. You'd have to look into that a bit. But essentially, if a request is made for electronic records and you maintain them only on paper, if you can readily convert them to electronic to comply with the patient's request, you need to be able to do that. The records need to be provided to the patient no later than 30 calendar days after the request for the records, and you obviously should do it as soon as possible, but there is a time frame involved. You need to provide those records in a timely fashion, which is within 30 days after the request. Finally, what can you charge for providing the records? Well, HIPAA is very clear that you cannot charge, you can only charge for certain items. You can only charge for the actual labor cost in making the copies. Any supplies that you have to use in providing the copies. For example, if a patient asks that they get electronic records on a thumb drive or some kind of device like that, and the device costs $5, you can charge them the $5 for the device. You can also charge them for paper and ink for copying, that type of things, but you can't charge for your office overhead. You can't charge for the cost of searching for the records. It's a very limited universe of things that you can charge for. So if you're going to charge, you need to make sure that you've looked at HIPAA and what you can charge legally and not charge more than that. In addition, if you are going to charge patients for copies of their medical records, you need to provide them in advance with an estimated cost of what that charge is going to be before you send them a bill for those costs. HIPAA does require that if you are going to charge the patient for a copy of the records, that they be told in advance what the estimated costs will be. That's about it for today. Just wanted to throw this out for you to make sure you're aware of the OCR's Right to Access initiative and how significant and important it is for doctors and other healthcare providers to comply. Otherwise, you can end up on the wrong side of an OCR enforcement action and end up paying some extra legal expenses and a fine or fee to settle with the government, which so far, like I said, has ranged from a low of $10,000 and has gone up from there. So anyway, I hope that helps. Hope this is information you can use. If you have any questions, please feel free to reach out and ask, and I'll be glad to talk to you about it. Thanks.